Welcome back, future criminologists. In this video, I will be discussing original and appellate jurisdiction, exclusive and concurrent jurisdiction, general and special jurisdiction. Let us discuss first original and appellate jurisdiction. Courts of original jurisdiction. The term original jurisdiction refers to the question of which court has the authority or jurisdiction to hear a legal case for the first time. For example, the municipal trial court has original jurisdiction to try the crime of slight physical injuries. The crime of slight physical injuries should be first filed with the municipal trial court before other courts such as the regional trial courts, Court of Appeals, or the Supreme Court. The regional trial court, by law, has original jurisdiction to try and decide cases in violation of the Dangerous Drugs Act. Thus, if the crime committed was possession of dangerous drugs, the case should be filed first with the regional trial court before other courts such as the Court of Appeals or Supreme Court. The municipal trial court, even if lower than the regional trial court, has no jurisdiction to try drugs cases. Courts of Appellate Jurisdiction. Appellate jurisdiction refers to the court authorized to hear the appeal of a case that was originally heard by a court of original jurisdiction. Appellate jurisdiction is relied on by the appeals court when reviewing lower court decisions. This does not mean, however, that the appeals court will hear all the details of the case. The purpose of hearing a case in its entirety is for a trial, and an appeal is not a second trial, but rather a review of the facts surrounding what the appellant claims to be an error in the proceedings. Here, the appellate court determines if the lower court made a mistake when it applied the relevant law to a case or in some procedure during the trial. On appeal, an appellate court is empowered to either alter or reverse the lower court's decision, should the appellate court find there to be an error in the lower court's decision. For example, the municipal trial court has original jurisdiction to try the crime of slight physical injuries. If the decision is not favorable to the accused can appeal the case to the regional trial court, which has appellate jurisdiction to try cases decided by the municipal trial court. This topic is related to the principle of hierarchy of courts, which will be discussed later on in a separate video. Or if you're watching this on a later date, you can check the description box for the link. Now we go to exclusive and concurrent jurisdiction. Exclusive jurisdiction. Exclusive jurisdiction exists where one court has the power to adjudicate a case to the exclusion of all other courts. It is the sole forum for determination of a particular type of case. For example, the municipal trial court has exclusive jurisdiction to try the crime of slight physical injuries. Under the law, all offenses punishable with imprisonment not exceeding 6 years, irrespective of the amount of fine and regardless of other imposable accessory or other penalties, are within the exclusive jurisdiction of the municipal trial court. The crime of slight physical injuries is punished with the penalty of arresto minor, or imprisonment from 1 day to 30 days. In other words, the municipal trial court has original and exclusive jurisdiction over the crime of slight physical injuries. Original kasi sa MTC siya unang i-file. Exclusive kasi MTC mo lang siya pwedeng i-file. Concurrent jurisdiction. The jurisdiction is said to be concurrent when two or more different courts possess the authority to hear and decide on the same matter within the same territory. Concurrent jurisdiction is the ability to exercise judicial review by different courts at the same time, within the same territory and over the same subject matter. In this case, more than one court may take jurisdiction over the case. For example, the Sandigan Bayan has concurrent jurisdiction together with the Regional Trial Court where the threat, act, or omission was committed or any of its elements occurred, the Court of Appeals, and the Supreme Court to try petitions for the issuance of writ of amparo and writ of habeas data. Thus, in petitions for the issuance of writ of amparo or writ of habeas data, the complainant may file his petition either with the Supreme Court, Court of Appeals, Sandigan Bayan, or the Regional Trial Court where the threat, act, or omission was committed or any of its elements occurred. General and Special Jurisdiction. Courts of General Jurisdiction. They are courts with competence to decide on their own jurisdiction and to take cognizance of all cases, civil and criminal, of a particular nature. Courts of Special Jurisdiction. They are courts which have only a special jurisdiction for a particular purpose or are clothed with special powers for the performance of specified duties beyond which they have no authority of any kind. For example, the Municipal Trial Court, by virtue of special jurisdiction under Batas Pambansa bilang 129, can issue the writ of habeas corpus in case there is no available regional trial court judge. Here, the hierarchy of courts is not observed. To end, please subscribe to our channel and stay tuned for more videos.